branch in specific ways to resist specific deficiencies in the subpoenas that were issued. No fact witness is going to come in and say anything that relates in any way to that. It's not going to make any difference. And on the first article of impeachment, that too is defective on its face. And we've explained, we heard it again today here, that the way they have this subjective theory of impeachment that will show abuse of power by focusing just on the president's subjective motives. And they said again today here that the way they can show the president did something wrong is that he defied the foreign policy of the United States. And I talked about that before, this theory that he defied the agencies within the executive branch. He wasn't following the policy of the executive branch. That's not a constitutionally coherent statement. The theory of abuse of power that they framed in the first article of impeachment would do grave damage to the separation of powers under our Constitution, because it would become so malleable. They can pour into it anything they want to find illicit motives for some perfectly permissible action. It becomes so malleable, it's no different than maladministration, the exact ground that the framers rejected during the Constitutional Convention. The Constitution defines specific offenses. It limits and constrains the impeachment power. Now, there's also the fact that we actually heard from a lot of witnesses. We heard from a lot of witnesses in the proceedings so far. You've heard 192 video clips by our count from 13 different witnesses. There were 17 witnesses deposed in closed hearings in the House, and 12 of them testified again in open hearings. You've got all of those transcripts, so you can see the witnesses' testimony there. The key portions have been played for you on the screens. And you've got over 28,000 pages of documents and transcripts. You've got a lot of evidence already. But there's another principle that they overlook when they say, well, if you're going to have a trial, there just have to be witnesses, as if the most ordinary thing is you get to trial and then start subpoenaing new witnesses and documents. That's not true either. And we pointed this out. In the regular courts, the way things work is you've got to do a lot of work preparing a trial called discovery to find out about witnesses and depose them and find out about documents before you get to trial. You can't show up the day of trial and say, oh, Your Honor, actually, we're not ready. We didn't subpoena John Bolton or witness X or witness Y. And now we want to subpoena that witness. Subpoena John Bolton or witness X or witness Y. And now we want to subpoena that witness. Now we want to do discovery. And why does that matter here? Because here, to show up not having done the work and to expect that work to be done in the Senate by this body has grave consequences for the institutional interests of this body, and it sets a precedent. Really, it sets an important precedent for two bodies, for the Senate and for the House. Because what the Senate accepts as an impeachment coming from the House determines not just precedent for the Senate, but really precedent for the House in the future as well. If the procedures used in the House to bring this proceeding here to this stage are accepted, if the Senate says, yes, we'll start calling new witnesses because you didn't get the job done, and whatever process you used to get it here, then that becomes the new normal. And that's important in a couple of ways. One is, as we've pointed out, the totally unprecedented process that was used in the House that violated all notions of due process. There are precedents going back 150 years in the House ensuring that someone accused in an impeachment hearing in the House has due process rights to be represented by counsel, to cross-examine witnesses, to be able to present evidence. They didn't allow the president to do that here. And if this body says that's okay, then that becomes the new normal. And they stand up here, the House managers, and say, this body would be unfair if this body doesn't call the witnesses. They talk about fairness. Where was the fairness in that proceeding in the House. And Manager Schiff says things would be arbitrary if you don't do what they say and call the witnesses they want. Well, wasn't it arbitrary in the House when they wouldn't allow the president to be represented by counsel, wouldn't allow the president to call witnesses? There was no precedent in a presidential impeachment inquiry to have open hearings where the president and his counsel were excluded. It also would set a precedent to allow a package, a proceeding from the House to come here that the House managers say, well, now we need new witnesses. We haven't done all the work. And it's witnesses they didn't even try to get. They didn't subpoena John Bolton. And they didn't go through the process when other witnesses were subpoenaed. When Dr. Kupperman, Charlie Kupperman, went to court, they withdrew the subpoena. And now to say that, well, fairness demands that this body has to do all that work, that sets a new precedent as well. And it would change for all the future the relationship between the House and the Senate in impeachment inquiries. It would mean that the Senate has to become the investigatory body. And the principles that they assert, they did a process that wasn't fair. They did a process that was arbitrary, that arbitrarily denied the president rights. They did a process that wouldn't allow witnesses. And then they came here on the first night. Remember when we were all here until 2 o'clock? And in very belligerent terms said to the members of this body, you're on trial. It will be treachery if you don't do what the House managers say. That's not right. When it was their errors, when they were arbitrary and they didn't provide fairness, they can't project that onto this body to try to say that you have to make up for their errors, and if you don't, the fault lies here. Now, they also suggest that it's not going to take a long time, that they only want a few witnesses. But of course, if things are opened up to witnesses, and it is going to be fair, it's not just one side, it's not just the witnesses that they would want. The president would have to be permitted to have witnesses. And with all respect, Mr. Chief Justice, the idea that if a subpoena is sent to a senior advisor to the president, and the president determines that he will stand by the principle of immunity that's been asserted by virtually every president since Nixon, that'll just be resolved by the Senate right here, whether or not that privilege exists, by the Chief Justice sitting as presiding officer. That doesn't make sense. That's not the way it works. The Senate, even when the Chief Justice is the presiding officer here, can't unilaterally decide the privileges of the executive branch. That dispute would have to be resolved in another way, and it could involve litigation, and it could take a lot of time. So the idea that this will all be done quickly, if everyone just does what the House managers say, is not realistic. It's not the way that the process would actually have to play out in accord with the Constitution. And that has another significant consequence. Again, affecting this institution as a precedent going forward. Because what it suggests, the new normal that would be created then is kind of an express path for precisely the sort of impeachments that the framers most feared. The framers recognized that impeachments could be done for illegitimate reasons. They recognized that there could be partisan impeachments. And if this is the new normal, this is the very epitome of a partisan impeachment. There was bipartisan opposition to it in the House, and it was rushed through with unfair procedures, 78 days total of inquiry. Think about that. In Nixon, there had been investigating committees, and there was a special prosecutor long before the House Judiciary Committee started its investigation. In Clinton, there was a special counsel, an independent counsel, for the better part of a year before the House Judiciary Committee even started hearings. Everything, from start to finish, in this case, from September 24th to the articles of impeachment were considered in the Judiciary Committee, was done in 78 days. In 78 days, and for the 71 of them, the president was entirely locked out. So the new normal would be slapdash, get it done quickly, unfair procedures in the House to impeach a president, then bring it to the Senate, and then all the real work of investigation and discovery is going to have to take place with that impeachment hanging over the president's head. And that's a particular thing that the framers also were concerned about. And I mentioned this the other day. In Federalist number 65, Hamilton warned specifically about what he called, and I'm quoting, the injury to the innocent from the procrastinated determination of the charges which might be brought against them. Because he understood that if an impeachment charge from the House wasn't resolved quickly, if it was hanging over the president's head, that in itself would be a problem. And that's why they structured the impeachment process so that the Senate could be able to swiftly determine impeachments that were brought. That also suggests that's why there is a system for having thorough investigation, thorough process done in the House. And Hamilton explained that delay after the impeachment would afford an opportunity for intrigue and corruption. And it would also be, as he put it, a detriment to the state from the prolonged inaction of men whose firm and faithful execution of their duty might have exposed them to the persecution of an intemperate or designing majority in the House of Representatives. And that's what's happened here. And if you create a system now that makes the new normal a half-baked slapdash process in the House, just get the impeachment done and get it over to the Senate, and then once the president's impeached, and you have the head of the executive branch, the leader of the free world, having something like that hanging over his head, then we'll slow everything down, and then we'll start doing the investigation and just drag it out. That's all part of what makes this even more political, especially in an election year. It's not the process that the framers had in mind, and it's not something the Senate should condone in this case. The Senate is not here to do the investigatory work that the House didn't do, where there's been a process that denied all due process, that produced a record that can't be relied upon. The reaction from this body should be to reject the articles of impeachment, not to condone and put its imprimatur on the way the proceedings were handled in the House, and not to prolong matters further by trying to redo work that the House failed to do, by not seeking evidence and not doing a fair and legitimate process to bring the articles of impeachment here. Thank you.
Mr. Sekulow.
Chief Justice, members of the Senate, over a 7-day period, you did hear evidence. You heard evidence from 13 different witnesses, 192 video clips, and as my colleague, the Deputy White House Counsel said, over 28,000 pages of documents. You heard testimony from Gordon Sondland. He's the United States Ambassador to the European Union. You heard that testimony. He testified in the House proceedings.
Hi there, everybody. I'm Russ Lewis here live in the KHOU newsroom. We're going to break away now from CBS's coverage of the president's impeachment trial. If you would like to continue watching that, you can do so on KHOU.com, also on the KHOU mobile news app. We'll go to the Ellen Show here after the commercial break. Then we will see you here after that for the 411 starting in about 1 hour. We'll see you then.
Tim Morrison.
All those apps you just don't use are slowing down your phone. New year, new you. Delete the clutter and download the app that has everything. The KHOU 11 News app. Your home screen never looks so good.
If your time is valuable and you value convenience, shop Gallery Furniture Day. See a huge selection of furniture, low
Opportunity. David Holmes, the political counsel at the United States Embassy in Ukraine, saw testimony from him. We're not able to cross-examine. If he's called, or if we get witnesses, we will call the ambassador and we will cross-examine. Lieutenant Colonel Alexander Vidman, you saw his testimony, appear before the House. We didn't have the opportunity to cross-examine him. If we call witnesses, we will, of course, have that right to cross-examine him. Fiona Hill, she is the former Senior Director for Europe and Russia on National Security Council. She testified before the House. If we have witnesses, we have the opportunity to call her then and cross-examine Fiona Hill. Kurt Volker, former United States Special Representative for Ukraine negotiations. They called him. We did not have the opportunity to cross-examine. If we're calling witnesses, these are witnesses you've heard from, we would have the right to call witnesses and to cross-examine Mr. Volker. George Kent, the Deputy Assistant Secretary of State for the Bureau of European and Eurasian Affairs. You saw his testimony. They called him. If we have witnesses, we have the right to call that witness and to cross-examine Deputy Assistant Secretary Kent. The former United States Ambassador to Ukraine, Ambassador Yovanovitch, they called her. You saw that testimony. We did not have the opportunity to cross-examine her. If we have witnesses, we would have to call her. Laura Cooper, Deputy Assistant Secretary of Defense for Russia, Ukraine, and Eurasia. They called her. You saw her witness testimony right here. We did not have the opportunity to cross-examine her. We would have to be given that opportunity. These are witnesses against the President. Laura Cooper, Deputy Assistant Secretary of Defense for Russia, Ukraine, and Eurasia. Again, same thing. David Hale, Undersecretary of State for Political Affairs. He was called by the House. You saw his testimony. We never had the opportunity to cross-examine. If we have witnesses, we have to have the opportunity to do that. There were other witnesses that were called, or you saw their testimony or heard their testimony, where it was referred to: Catherine Croft, the Special Advisor for Ukraine Negotiations, Department of the State; Mark Sandy, the Deputy Associate Director for National Security Programs; and Christopher Anderson, Special Advisor for Ukraine Negotiation, Department of State. You heard their testimony referred to. We did not have the opportunity to cross-examine them. So this isn't going to happen if witnesses are called in a week. Now, that's just the witnesses that have been produced that you have seen by the House managers. You are being called upon to make consequential constitutional decisions. Consequential decisions for our Constitution. We talk about the burden of proof. I've said this before, I'll say it again. 31 times the manager said they proved their case. 29 times they said the evidence was overwhelming. Manager Nadler, he didn't only say it was overwhelming in his view. On page 739 of the congressional record, he's very clear. He says, not only is it strong, there is no doubt. That's what he says. The one thing that the House managers think the President and Council's got right is quoting me, talking about Mr. Nadler, Manager Nadler, as saying, beyond any doubt, it is indeed beyond any doubt. Now, of course, we think that they have not proven their case by any stretch of any proper constitutional analysis. In the Clinton investigation, they talk about witnesses being called, but the 3 witnesses that were called had either testified before the grand jury or before the House committees. These weren't new witnesses. What Mr. Philbin said is correct. Under our constitutional design, they're supposed to investigate. You are to deliberate. But what they're asking you to do is now become the investigative agency, the investigative body. If they needed all this additional evidence, which they said they don't need, and by the way, not only did they say it in the record, this is House Manager Nadler, quote, this is on, when he was on CNN back on the 15th of this month, "We brought the articles of impeachment because despite the fact that we didn't hear from many witnesses, we heard from enough witnesses to prove the case beyond any doubt at all. The same can be said of Representative Lofgren. You know, we have evidence proving the case through, for example, at the meeting when Bolton said it was a drug deal. Well, we have fact witnesses. Hill was there, Vindman was there, Sondland was there." So this idea that they haven't had witnesses, that's the smokescreen. You've heard from a lot of witnesses. The problem with the case, the problem with their position is, even with all of those witnesses, it doesn't prove up an impeachable offense. The articles fail. I think it's very dangerous if the House runs up, which they did, articles of impeachment quickly. So quickly that they are clamoring for evidence, despite the fact that they put all of this evidence forward. They got their wish of an impeachment by Christmas. That was the goal. But now they want you to do the work they failed to do. But as I said, time and time again we heard, you didn't hear from witnesses, you didn't hear from many witnesses. Mr. Schiff modified that a little bit today. A little bit. You heard from a lot of witnesses. But if we go down the road of witnesses, this is not a one-week process. Remember I talked about the waving the wand and Ukrainian corruption in Ukraine was gone. You're not going to have a witness wand here where we just say, okay, you got a week to do this and get it done. There's no way that would be proper under due process. But you know, due process is supposed to be for the person accused. And they are turning it on its head. They brought the articles before you. They're the ones that rushed the case up and then held it before you could actually start the proceedings. But they're the ones that passed the articles before Christmas. You know, we talked a lot about the court system and the fact that they were seeking witnesses, and when it got close to actually having a court proceeding, they decided that they didn't want to have that witness go through that proceeding. They actually withdrew the subpoena to moot the case out. How many constitutional challenges will we have in this body because they placed a burden on you that they wouldn't take themselves in putting their case forward? If we look at our constitutional framework and our constitutional structure, that's not the way it's supposed to work. Now, our opposition to this motion is rather straightforward, as I've said. We came here ready to try the case on the record that they presented. The record that the managers told us was overwhelming and complete. Mr. Schiff went through every sentence of the articles of impeachment just a few days ago and said, proved, proved, proved. The problem is what it proved is not an impeachable offense. You could have witnesses that prove a lot of things, but if there's not a violation of a law, if it doesn't meet the constitutional required process, the constitutional required substantive issues of do these articles, these allegations rise to the level of a sufficient for a removal of office for a duly elected president of the United States? It doesn't. And especially so when we are in an election year. I am not going to take the time, your time, which is precious, to go over in each and every allegation about witnesses that I could. I could do it. I could stand here for a long time. I'm not going to do that. I'm just going to say this. They created the record. Do not allow them to penalize the country. and the Constitution because they failed to do their job. With that, Mr. Chief Justice, we yield our time.
Thank you, counsel. The House managers have 30 minutes remaining.
Thank you, Mr. Chief Justice. Senators, I want to walk through some of the arguments that you've just heard from the President's counsel. The first were arguments made by Mr. Philbin. Mr. Philbin began by saying the House managers assert that you can't have a trial without witnesses. And he said it's not that simple. Actually, it is. It is pretty simple. It is pretty simple. In every courthouse, in every state, in every county in the country where they have trials, they have witnesses. And I think you heard Mr. Philbin tie himself into knots as to why this should be the first trial in which witnesses are not necessary. But you know, some things are just as simple as they appear. A trial without witnesses is simply not a trial. You can call it something else, but it's not a trial. Now, Mr. Sekulow said something very interesting. He said, the House investigates and the Senate deliberates. Well, he would rewrite our Constitution with that argument. Because the last time I checked the Constitution, it said that the House shall have the sole power of impeachment and the Senate shall try the impeachment. Not merely deliberate about it, not merely think about it, not merely wonder about it. I know you're the greatest deliberative body in the world, but not even you can deliberate in a trial without witnesses. But Mr. Sekulow would rewrite the Constitution. Your job is not to try the case, he says. Your job is merely to deliberate. That is not what the founders had in mind, not by a long shot. Now, Mr. Philbin says none of these witnesses would have relevance on Article 2, I guess conceding that they would have relevant evidence on Article 1. But that's not true either. Imagine what you will see when you hear from the witnesses who ran the Office of Management and Budget, or imagine what you will see when you read the documents from the Office of Management and Budget. What you will see is what they have covered up. What you will see is the motive for their complete obstruction of Congress. When you see not the redacted emails, not the fully blacked out emails that they deigned to give in the litigation under the Freedom of Information Act, but when you see what is under those redactions, you will have proof of motive. When you see those documents, you will see just how fallacious these non-assertions of executive privilege are. You will see, in essence, what they have covered up. It could not be more relevant to whether their panoply of legal argumentation to justify we shall fight all subpoenas is merely a cover-up and legal window dressing. So these witnesses and documents are critical on both articles. Now, you also heard Mr. Philbin argue, and again, this is where we expected we'd be at the end of the proceeding, which is essentially they proved their case. They proved their case. We pretty much all know what's gone on here. We all understand just what this president did. No one really disputes that anymore. So what? So what? It's a version of the Dershowitz defense. So what? The president could do no wrong. The president is the state. If the president believes that corrupt conduct would help him get reelected, if he believes shaking down an ally and withholding military aid, if he believes soliciting foreign interference in our election, whether it be from the Ukrainians or the Russians or the Israeli prime minister or anyone else in any form that it may take, so what? He has a God-given right to abuse his power. And there's nothing you can do about it. It's the Dershowitz principle of constitutional lawlessness. That's the end-all argument for them. You don't need to hear witnesses who will prove the president's misconduct because he has a right to be as corrupt as he chooses under our Constitution. And there's nothing you can do about it. God help us if that argument succeeds. Now, they say that these witnesses already testified, and so you don't need to hear from anybody. There were witnesses who already testified, and so the House doesn't get to call witnesses in the Senate. That would be like a criminal trial in any courthouse in America where the defendant, if he's rich and powerful enough, can say to the judge, "Hey, judge, the prosecution got to have witnesses in the grand jury. They don't get to call anyone here. They had their chance in the grand jury. They called witnesses in the grand jury. They don't get to call witnesses here." That's not how it works in any courtroom in America, and it's not how it should work in this courtroom. Of course, you heard the argument again, repeated time and time again. The House is saying they're not ready for trial. Of course, we've never said we weren't ready for trial. We came here very prepared for trial. I would submit to you the president's team came here unprepared for trial, unprepared for the fact that there would be, as we all anticipated, a daily drip of new disclosures that would send them back on their heels. We came here to try a case, prepared to try a case, and yes, we had, I hope, the not unreasonable expectation that in trying that case, like in every courtroom in America, we could call witnesses. That is not a lack of preparation, that is the presence of common sense. They didn't try to get Bolton, they argued. Mr. Philbin said they didn't even try to get Bolton. Now, of course, we did try to get Bolton. And what he said when he refused to show up voluntarily is, "If you subpoena me, I will sue you. I will sue you." He said basically what Don McGahn told us 9 months ago. "I will sue you. Good luck with that." Now, the public argument that was made by his counsel was that he and Dr. Kupperman, out of just due diligence, they just want a court to opine that it's okay for them to come forward and testify. As soon as the court blesses their testimony, they're more than willing to come in. They just are going to court to get a court opinion saying they could do it. And so, of course, we said to them, if that's your real motivation, there's a court about to rule on this very issue of absolute immunity. And very shortly thereafter, that court did. That was the court, Judge Jackson, in the McGahn case, and the judge said this argument about absolute immunity, which, yes, presidents have always dreamed about and asserted, but which has never succeeded in any court in the land. It was ridiculed in the case of Harriet Miers. It was made short shrift in the case of Don McGahn, where the judge said, no, we don't have kings here. In the 250 years of jurisprudence, there is not a single case to support the proposition that the president can simply say that my advisors are absolutely immune from process. And of course, in every other non-impeachment context where the courts have looked at the issue of a Congress's power to enforce its subpoenas against witnesses or documents, the courts have said the power to compel compliance to a subpoena is co-equal, coextensive with the power to legislate, because you can't do one without the other. If we can't find out whether the president is breaking the law, violating the Impoundment Control Act or any other when he is withholding aid we appropriated from an ally, how can we legislate a fix to make sure that this never happens again? We can't. If we can't get answers, we can't legislate. That is a proposition vindicated by every court in the land, and of course in the context of impeachment, the courts have said that is never more important. Never more important. Now, I don't know why, after saying he would sue us, and we had to expect that, like Don McGahn, where we are still in court 9 months later, I don't know why he's changed his mind. But I suspect it's for the reason that if this trial goes forward and he keeps this to himself, it will be very difficult to explain to the country why he saved it for the book. When he knew information of direct relevance and consequence to a decision that you have to make about whether a president of the United States should be removed from office, it will be very difficult to explain why that was saved for a book. Well, I would submit to you it will be equally difficult for you to explain as it would be for him. But you can ask him that question. Why are you willing to testify before the Senate but not the House? And you should ask him that question. Now, it was said, and it has the character of, you should have fought harder to overcome our obstruction. The House should have fought harder to overcome our stonewalling. Shame on the House for not fighting harder to overcome our stonewalling. If only they had fought harder to overcome our stonewalling, maybe they could have gotten these witnesses earlier. That's a really hard argument to make while they're stonewalling. You should have tried harder. You should have taken the years that would be necessary to overcome our stonewalling. And the reason why that argument is in such bad faith, as I pointed out to you yesterday, that while they're in this body arguing the House was derelict, slapdash, they should have fought harder and longer and endlessly to overcome our stonewalling, while they're making that argument to you, the House should have fought up and down the courts, from the district to the Court of Appeals, the Supreme Court, and back again. They're in the courthouse arguing the opposite. They're in the courthouse saying, Judge, they're trying to enforce a subpoena on Don McGahn. You need to throw it out. They don't have the jurisdiction. This is non-justiciable. You can't hear this case. That is a really hard argument to make. I credit them for making it with a straight face. But that's the character of it. You should have fought harder to overcome our stonewalling and obstruction. Now, they also say the Chief Justice cannot decide issues of privilege. No, the Chief Justice can't make those decisions. You need to let us litigate this up and down the court system. That's a pretty remarkable argument, because the Senate rules allow the presiding officer to make judgments to rule on issues of evidence, materiality, and privilege. That is permitted under your own rules. We don't need to go up and down the courts. We've got a perfectly good judge right here. Now, you heard our proposal yesterday that we take a week, just a week, to depose the witnesses that we feel are relevant, that they feel are relevant, and that the justice rules are relevant. Just 1 week. Now, they can say that the Constitution requires them to go to court, but of course it doesn't. There is absolutely no constitutional impediment from these fine lawyers saying, you know, that's eminently reasonable. We will allow a neutral party, the Chief Justice of the United States of America, to rule on whether a witness is material or immaterial, whether they're being called for purposes of probative evidence or harassment, and whether you're making a proper claim of privilege or merely trying to hide crime or fraud. The concern they have is not that this Chief Justice will be unfair, but rather that he will be fair. But do not make any mistake about it. Do not let them suggest that there is something constitutionally impermissible, or it would violate the President's rights to allow the Chief Justice of the United States to make those decisions in this court, because he is empowered to do so by your rules and by the Constitution, which gives you the sole power to try impeachments. In the sole exercise of your power to try impeachments, you can say, we will allow the Chief Justice to make those decisions. Now, Mr. Sekulow said that you've heard the testimony of 13 witnesses. And I think the impression is meant to be given, if not to you, who know otherwise, then maybe to the people watching at home, that they must have been in between errands while watching the Senate trial and missed where those 13 witnesses came before the Senate and testified. But of course, you heard no live testimony in this body. There wasn't any live testimony before this body, and I don't recall any of you in that super secret basement bunker they've been talking about. Now, I'll admit there were 100 members eligible to be there, so maybe I missed one of you. But I don't think you were there for the live testimony in the House. Now, Mr. Sekulow says the President was deprived of his right of calling these witnesses himself and cross-examining these witnesses in the House, but that's not true either, because the President was eligible to call witnesses in his defense in the Judiciary Committee and chose not to do so. If the President's counsel felt that, you know, Bill Taylor says that he spoke with Sondland right after this phone call with the President, and Sondland talked about how the military aid was conditioned on these investigations. The President wanted Zelensky in a public box. And I'd really like to cross-examine that West Point grad Vietnam vet, because I don't believe him. You know, they could have called Bill Taylor in the Judiciary Committee and cross-examined him. Or they could have called Mick Mulvaney and put him under oath and let him contradict what we now John Bolton would say. But of course they didn't do that. No, they said merely, just get it over with in the House. For all there was too quick, too slapdash, get it over with in the House. Because as the President said, when it comes to the Senate, we'll have a real trial where he gets to call witnesses. But they've changed their tune, because now they know what they really have known all along, which is those witnesses would deeply incriminate this President. And so, instead, they have fallen back on the argument that if we're going to go down the road to having a real trial, if we're going to go down the road into having a real trial, we, the President's lawyers, are going to make you pay. And the form of this argument is, we are going to call every witness under the sun. We're going to call every witness that testified before the House. We're going to call every witness that we can think of that would help smear the Bidens. We are going to keep you here until kingdom come. That's essentially the argument that they're making when Mr. Sekulow says we're going to bring in Fiona Hill and we're going to bring in Tim Morrison, we're going to bring in this witness and bring in that witness. You have the sole power to try this case. You do not have to allow the President's lawyers to abuse your time or this process. You have the power to decide, no, we gave each side 24 hours to make their arguments. We're going to give each side a shared week to call their witnesses. You have that power. If you didn't, you couldn't have constricted the amount of time for our argument. You can likewise determine how much time should be taken with witness testimony. Now, Mr. Sekulow ended his argument against witnesses with where Mr. Philbin essentially began. It all comes back to the Dershowitz principle. What's the point of witnesses if the President can do whatever he wants under Article 2. What's the point of calling witnesses? What's the point of having a trial if the president can do whatever he wants under Article 2? The only constraining principle, and I think that one of the senators asked yesterday, what's the limiting principle in the Dershowitz argument? If a president can corruptly seek foreign interference in his election because he believes that his election is in the national interest, then you cannot impeach him for it, no matter how damaging it may be to our national security. What is the limiting principle? And I suppose the limiting principle is only this. It only requires the president to believe that his re-election is in the national interest. Well, it would require an extraordinary level of self-reflection and insight for a president of the United States to conclude that his own re-election was not in the national interest. Not unprecedented, mind you. I think that was the decision that LBJ ultimately arrived at. But I would not want to consider that a meaningful limitation on presidential power, and neither should you. Finally, counsel expressed some indignance that we should suggest that it's not just the Senate, it's not just the president, rather, who is on trial here, but it is also the Senate. How dare the House manager suggest that your decisions should reflect on this body? That's just such a calumny. Well, let me read you a statement made by one of your former colleagues. This is what former U.S. Senator John Warner, a Republican of Virginia, had to say. As conscientious citizens from all walks of life are trying their best to understand the complex impeachment issues now being deliberated in the U.S. Senate, the rules of evidence are central to the matter. Should the Senate allow additional sworn testimony from fact witnesses with firsthand knowledge and include relevant documents, he asks. As a lifelong Republican and a retired member of the U.S. Senate, who once served as a juror in a presidential impeachment trial, I am mindful of the difficult responsibilities those currently serving now shoulder. I believe, as I'm sure you do, that not only is the president on trial, but in many ways, so is the Senate itself. As such, I am strongly supportive of the efforts of my former Republican Senate colleagues who are considering that the Senate accept the introduction of additional evidence that they deem relevant. Not long ago, senators of both major parties always worked to accommodate fellow colleagues with differing points of view to arrive at outcomes that would best serve the nation's interests. If witnesses are suppressed in this trial, and a majority of Americans are left believing the trial was a sham, I can only imagine the lasting damage done to the Senate and to our fragile national consensus. The Senate embraces its legacy and delivers for the American people by avoiding the risk. Throughout the long life of our nation, federal and state judicial systems have largely supported the judicial norms of evidence, witnesses, and relevant documents. I respectfully urge the Senate to be guided by the rules of evidence and follow our nation's judicial norms, precedents, and institutions to uphold the Constitution and the rule of law by welcoming relevant witnesses and documents as part of this impeachment trial. That is your colleague, former Senator John Warner. Senators, there is a storm blowing through this Capitol. Its winds are strong, and they move us in uncertain and dangerous directions. Jefferson once said, "I consider trial by jury as the only anchor yet imagined by man, by which a government can be held to the principles of its Constitution. The only anchor ever imagined, yet imagined by man, by which a government can be held to the principles of its Constitution. I would submit to you, remove that anchor, and we are adrift. But if we hold true, if we have faith that the ship of state can survive the truth, this storm shall pass. I yield back.
Thank you, Mr. Manager.
Mr. Chief Justice,
The Majority Leader
I
is
suggest
recognized.
the absence of a quorum.
The clerk will call the roll.
Mr. Alexander.
Okay, colleagues, if everyone would return to their desk. I ask consent that further proceedings on the quorum call be dispensed with.
Without objection,
The Democratic leader and I have had an opportunity to have a discussion, and it leads to the following. We'll now cast a vote on the witness question, and once that vote is complete, I would ask that the Senate stand in recess, subject to call of the chair.
thank you. Without objection, so ordered. The question is, shall it be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents? The yeas and nays are required under Senate Resolution 483. The clerk will call the roll.
Mr. Alexander? No. Ms. Baldwin? Aye. Mr. Barrasso? No. Mr. Bennett? Aye. Mrs. Blackburn? No. Mr. Blumenthal? Mr. Blunt? No. Mr. Booker? Aye. Mr. Bozeman? No. Mr. Braun? No. Mr. Brown? Aye. Mr. Burr? No. Ms. Cantwell? Aye. Mrs. Capito? No. Mr. Cardin? Aye. Mr. Carper? Aye. Mr. Casey? Aye. Mr. Cassidy? No. Ms. Collins? Aye. Mr. Coons? Aye. Mr. Cornyn? No. Ms. Cortez Masto? Aye. Mr. Cotton? No. Mr. Kramer? No. Mr. Crapo? No. Mr. Cruz? No. Mr. Daines? No. Ms. Duckworth? Aye. Mr. Durbin? Aye. Mr. Enzi? No. Ms. Ernst? Mrs. Feinstein? Aye. Ms. Ernst, no. Mrs. Fisher? No. Mr. Gardner? No. Mrs. Gillibrand? Aye. Mr. Graham? No. Mr. Grassley? No. Ms. Harris? Aye. Ms. Hassan? Aye. Mr. Hawley? No. Mr. Heinrich? Aye. Ms. Hirono? Aye. Mr. Hoven? No. Mrs. Hyde-Smith? No. Mr. Inhofe? No. Mr. Johnson? No. Mr. Jones? Aye. Mr. Kane? Aye. Mr. Kennedy? No. Mr. King? Aye. Ms. Klobuchar? Aye. Mr. Langford? No. Mr. Leahy? Aye. Mr. Lee? No. Mrs. Loeffler? No. Mr. Manchin? Aye. Mr. Markey? Aye. Mr. McConnell? No. Ms. McSally? No. Mr. Menendez? Aye. Mr. Merkley? Aye. Mr. Moran? No. Ms. Murkowski? No. Mr. Murphy? Aye. Mrs. Murray? Aye. Mr. Paul? No. Mr. Perdue? No. Mr. Peters? Aye. Mr. Portman? No. Mr. Reed? Aye. Mr. Risch? No. Mr. Roberts? No. Mr. Romney? Aye. Ms. Rosen? Aye. Mr. Rounds? No. Mr. Rubio? No. Mr. Sanders? Aye. Mr. Sass? No. Mr. Schatz? Aye. Mr. Schumer? Aye. Mr. Scott of Florida? No. Mr. Scott of South Carolina? No. Mrs. Shaheen? Aye. Mr. Shelby? No. Ms. Sinema? Aye. Ms. Smith? Aye. Ms. Stabenow? Aye. Mr. Sullivan? No. Mr. Tester? Aye. Mr. Thune? No. Mr. Tillis? No. Mr. Toomey? No. Mr. Udall? Aye. Mr. Van Hollen? Aye. Mr. Warner? Aye. Ms. Warren? Aye. Mr. Whitehouse? Aye. Mr. Wicker? No. Mr. Wyden? Aye. Mr. Young? No. Mr. Blumenthal? Aye.
Are there any senators in the chamber wishing to change his or her vote? If not, the yeas are 49. The nays are 51. The motion is not agreed to. Under the previous order, the Senate stands in recess, subject to the call of the chair.
Man, you beat everyone down here. It's good cardio, right? Huh? Yeah, that's fine. How are they? Your talk's going with McConnell.